views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of Bronxnet or the program underwriters.
Coming up on this edition of Today's Verdict, the Fourth Amendment protects citizens from unreasonable searches and seizures. Every day, citizens from our city complain of being detained without justification. On tonight's episode, we will have an expert on set to let our viewers know what rights they have when the police come knocking on their door. And speaking of criminal law, we take a look at a new law that allows felonies to be and stay sealed from the public. As you can see, we have much to get to, so stay tuned. Today's Verdict starts right now. Hello and welcome to Today's Verdict, a live and interactive show that gives you your legal rights and options. I'm your host and trial attorney David Lesh. Well, Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also make sure to like us and follow us on Facebook at Today's Verdict and check us out at bronxnet.tv/Bronx Legal. And last, but certainly not least, don't forget to tweet me at David Lesh. Although the Fourth Amendment was created as a protection against unreasonable searches and seizures, many believe our local law enforcement do not truly understand the protections that are afforded. Let's find out more with attorney Thomas Cuniff. How you doing, Thomas?
I'm doing well. Thanks for having me, David.
All right, let's go back to Law School 101 and talk a little bit about...
I slept through that.
Yeah, I know. Yeah, you and I both. Let's talk about the Fourth Amendment of the Constitution. Please, what is the Fourth Amendment?
Well, the Fourth Amendment is part of our Bill of Rights, as the name implies, and it's the right that protects us as citizens from unlawful searches and seizures. So you start with the premise that the Supreme Court has said that any warrantless search is per se unreasonable, unless, of course, the police can identify an exception. Now, most of the times when the police are acting in a street-side encounter here in New York City, and stopping, detaining someone, they don't have a warrant from a magistrate in their back pocket. So you have to ask yourself, what are the legal parameters that allow police to engage in these police-citizen encounters? And you have to find a balance. On the one hand, we don't want crime to run amok and criminals to be able to run the streets with guns and weapons and so forth because the police don't have an instant warrant in their back pocket. But at the same time, we don't want police willy-nilly detaining people on less than probable cause.
Which leads us right to the topic of stop and frisk. Sure. The viewers are constantly asking about it. I'm sure your clients also describe situations where they're stopped and detained and frisked. Let's talk about it. Mm-hmm. Is there still stop and frisk? Has there ever been a time where it's been stopped? Please, what do you think?
So one of the things that you have to do is really, separate the policies of the NYPD that took on the name Stop and Frisk under Mayor Giuliani and then Police Commissioner Bratton, and the law which governs police-citizen encounters street side, if you will. The Constitution of the United States and the Constitution in New York State and the Fourth Amendment and the 14th Amendment, which makes that applicable to the states, it never changed during the Giuliani administration, the Bloomberg administration, the de Blasio administration. It's always been the controlling law of the land, and the NYPD and the various mayoral administrations have been subject to it. And that means that the police just can't come up and stop and frisk someone without a proper basis for doing so. The stop and frisk policy was very controversial because that was basically, it started, like I said, under Giuliani, where the police were given a directive to use this tactic, ostensibly within the terms of the Constitution, because it was still governed by that law, but to use it in more creative or innovative ways than they perhaps ever had before.
Give me an example of something creative they would do.
So an example, people have cited that, look, there had been times under prior administrations in New York City where the police had, let's say, stopped someone for suspected marijuana use. They issued a desk appearance ticket or a summons, and they let the individual go unless they had really a founded suspicion that they had a weapon on them or were involved in, some pronounced criminal activity. Under stop and frisk, the thought was, well, look, if you have a summonsable offense or an arrestable offense, even though you may not suspect that there's any police danger, you can use the Constitution to justify conducting a stop and frisk or a frisk at that point that you might otherwise not have done, with the hopes that that's going to lead to some discovery of other criminal activity, hard drugs, a gun, a knife, or what have you.
Which many would argue actually worked in certain neighborhoods, but that doesn't necessarily mean that it's right.
Well, and that really is what led to the controversy with stop and frisk, because the reality was that these tactics were targeted at high crime areas. High crime areas, as we know, tend to be disproportionately minority for a variety of socioeconomic reasons that have nothing to do with minorities being predisposed to commit crime. And as a result, you've all heard of CompStat, which is the police started keeping statistics on all this back in the 90s. It's a very valuable tool in targeting crime. When the numbers came back on stop and frisk at the end of the year, the police would have conducted 90-some-odd% of their stop and frisks on minorities, Black, Hispanic, what have you. And that really led to people, including Judge Shira Shimlin in the Southern District, who had ultimately determined that the policy as applied was unconstitutional, not the Constitution itself, obviously, to take issue with this.
All right. But we're here today, and you tell me, do you still have clients who find that they're being harassed for very small, minor offenses, and the police are able to get into your pockets and do different things where they normally wouldn't be able to do that before?
As long as there's going to be a police department in this or any city, let alone one that's 35, 40,000 people, there's always going to be excesses. Right. What I will say is, if you listen to Mayor de Blasio, he'll tell you crime is down. There's a common belief among those in the system that it's not so much that crime is down, that policing is down. Because what you have now in the post-Bloomberg era, if you will, is a police department, given the changes in the administration and also given what we see on TV with all the controversies, too many to name, that are acting much less aggressively and much less proactively in policing crime. And a prime example of that is Manhattan. Up to 2-3 years ago, New York County itself traditionally had over 100,000 criminal dockets. Last year we just broke 70,000. This year we'd be hard pressed to make 70,000.
It's just an NYPD slowdown. It sounds like
it's a slowdown. It's them again. If the police are called, I'd like to think they're going to do their job. But are they out there aggressively looking for it the way they used to?
Before.
Not so much.
Quick question for you, because we get this from viewers as well. Somebody says that they were arrested, yet they were never read their rights.
Read my rights.
Well,
right.
What does that mean?
So one of the most common misunderstood, almost every other consult I do in my office where someone's meeting with me to potentially hire me as their criminal lawyer, one of the first things that comes out of their mouth was, I wasn't read my rights. And it's a significant misunderstanding that really comes from television.
Okay. And let's back up. What is your rights? What does that mean, Miranda? What does that mean?
The Supreme Court, in the famous decision of Miranda v. Arizona, which everyone knows, held that because unlawful police interrogations or unlawful tactics during police interrogations had become such an issue, and the Supreme Court itself has said that false confessions account for more false convictions than probably any other single thing in the criminal justice system. The Supreme Court said that we're going to require the police to read a series of warnings before they engage in what's called a custodial interrogation. This is where the confusion comes from. So the Miranda warnings, they are what we hear on TV, right to remain silent. Right to counsel if you can't afford a counsel.
Anything you say can and will be used against you.
Those are real, as seen on TV.
Yeah.
What's not real is that the police don't administer those warnings the moment they put cuffs on a perp or a defendant or an accused. They administer them, and they're required to administer them before they begin custodial questioning. Okay, that's not at the roadside at a traffic stop because that's investigatory questioning. The police can obviously
So that's back at the station, really.
Right, mostly. For the most part, we're talking back at the station. Custody could happen at the roadside. It could happen in an arrest at the house. Usually we're thinking those interrogations that we also see on TV, by the way, that occur back at the precinct. So you're not free to leave, and the police are questioning you. Where were you last night? What were you doing? Who were you with? Who does the knife belong to? Before those type of questions can be asked in a custodial setting, those Miranda warnings are triggered.
All right. Right of privacy, because we are really talking about the Fourth Amendment. A couple of scenarios. You tell me where you think you have one or you don't have one. Let's say somebody wants to come into your hotel room. Right of privacy, can they go in there, bust open and take a look what's in there?
Absolutely, they cannot.
They cannot.
All things being equal. So the warrant clause of the Fourth Amendment really applies probably most strongly in a home. And if you're a paid guest in a hotel, that's an extension of your living space.
Okay, a car.
Yes. Well, yes, it applies, and no, they cannot, all things being equal. So the car does not have the same sanctity as the home, but it still is entitled to a lot of protection. In fact, recent Supreme Court decisions, meaning within the last 5-10 years, have really extended the right of privacy in a car. It used to be that the police could search a car incident to a lawful arrest, not many questions asked. There was a case, the Gant case, which came down in 2009 out of the U.S. Supreme Court, which said that the police really can't get in the car unless they have a reasonable basis to believe either the instrumentalities of the crime are there or there's some threat to officer safety. Otherwise, they got to get a warrant to search the car, even if they arrest you as the occupant of the car.
I'm also fascinated by the DNA evidence. What right does somebody have to get that type of evidence from you? Is that private? Can they pull your hair? Can they get a piece of something off of you? Does that come up?
You have a privacy and a right to be free from a warrantless search of your body cavities and so forth. There are some exceptions for body cavities where there's a pronounced risk to public safety or an exigency. Usually what's required is a court order. If the DA wants to get what we see a lot here in New York is a buccal swab, a Q-tip swab of your cheek to compare it to DNA they found at the crime scene or another person's DNA, they have to ask for a court order to do that.
What about lastly, enhancement and like using telescopes or different things to see things they normally wouldn't be able to see?
Can create issues. Yeah, there's the Kelo case, which was another Supreme Court case from many years ago where the police were using a heat sensing device to scan. We all remember that, right? To someone's home, and that was considered a warrantless entry into the home, even though there was no physical police officer or agent entering.
So many different ways that somebody can have an unreasonable search and seizure. But let's say somebody's watching right now. Could you give any tips to somebody in terms of what you think they should or should not do if approached, let's say by an officer or somebody who wants to do some type of search? What would you say?
Well, what I would say is, it's never a good thing to escalate a situation, because there's also case law that says that even if the police initially act illegally, the place to deal with that is in a suppression court in the context of a criminal case if there is an arrest made, a civil rights lawsuit. But that does not give the person being stopped, detained, or searched license to commit independent illegal acts. So if you think you're being stopped illegally, and you don't have a right to haul off and punch the police officer.
And most importantly, where do we find you? Quickly.
NewYorkCityCriminalLawyers.com. The law firm is Razor & Kniff PC, 212-274-0090.
Good stuff, and thanks for being here.
Thanks for having me.
All right. We have to take a quick break, but don't worry, we'll be back with more of today's verdict right after this. Stay with us. Don't go anywhere. We take a picture when it's
We are neighbors and best friends.
I love my sister.
My heart doesn't see race. Love is love.
Our family is no less than any other family.
How can I help my daughter with her reading?
Searching for help with Dachshund reading.
No.
Let me try. Sarah's bright, but when she's reading, she has trouble sounding out words.
Playing world music.
What?
I give up.
Wait, I was trying to show you how Sarah feels every day. Frustrating, isn't it? Redirecting to understood.org.
Join parents and experts at understood.org, a free online resource about learning and attention issues to help your child thrive.
Welcome back to Today's Verdict. I'm your host, David Lesh. We are always encouraging you to stay connected. Tweet us at Today's Verdict. This month, a new law will take effect, giving New York one of the most expansive record-closing statutes. Courts will have the opportunity to seal up to 2 convictions for most crimes, excluding sex offenses and Class A violent felonies. Today we'll discuss the new sealing law with Wesley Keynes from the Bronx Defenders. Wesley, thanks for being here.
Thank you for having me.
Let's just back up for a second. What was the law with respect to your own criminal record with respect to felonies or certain types of crimes and sealing or not sealing them? What was the law before this new law?
Well, David, before this new law in New York State, barring being adjudicated a youthful offender, there was no sealing in New York State for felonies and misdemeanors. They do have sealing statutes on the books for violations and municipal offenses, but not for felonies and misdemeanors.
But not for the big ones, it wasn't?
Not for the big ones. This represents like a shift in New York's sealing statute laws.
Okay, and also while we're talking about sealing, we also have to talk about expunging, which is something you and I were talking about offset. What does it mean when something is expunged?
So New York does not have an expungement law.
It doesn't.
Which is a misconception that a lot of folks have, because a lot of other states do have expungement. And what expungement is simply a removing of the offense from your record, from your official record.
As if it just doesn't exist.
As if it just doesn't exist. Whereas sealing, it remains on the record, but it's only observable to certain small categories of organizations.
Now, why would
and
New
people.
York want to put something on the books that allows us to expunge certain offenses or certain misdemeanors forever? What's the thought behind that?
Well, that's a great question, and it's one that I think that New York should have an expungement law. The Bronx Defenders believe that there are certain policing policies that our community faces, and especially in this day and age where we have a recognition that stop and frisk, which you spoke to in your last segment, was deemed unconstitutional, and especially when we know that there's social change around marijuana arrests specifically, that there are a lot of the people in the community who have been impacted by the justice system. So I think for them, sealing shouldn't even be their option. It should be an expungement.
Completely expunged.
Exactly. But in New York State, I think the reason why historically expungement wasn't available has been because in New York has what's called a certificate of relief from civil disabilities or a certificate of good conduct. And it was actually at the forefront in the nation in issuing these documents, which are rehabilitative documents, which says to a prospective employer or to a state licensing agency that the state have deemed the individual who holds such certification as being rehabilitated. So those certificates were intended to remove the collateral consequences moving forward after justice involvement. But what has happened over the decades, because of mass incarceration, computer and internet access, just readily availability of public records around justice involvement, that those certificates don't have the same impact they once did. Where in 1978, someone may have committed a crime and maybe or maybe not gone to prison or jail and came home and got this certificate, they were pretty seamlessly able to
get another job.
Job because it wasn't so widely exposed that they had this history.
But that same person now, you Google his name or her name, and you have a slew of
it's there,
issues.
and that's particularly the challenge of those certificates. Although they serve a great purpose, in this day and age with the internet, they're not as effective. So I think that those of us who argue for expungement mainly because of that, just the technological climate that we live in.
And kind of get around and figure out what really happened.
Exactly.
All right, well, we're getting something here. At least we're getting a sealing law. Let's talk about that and what is still not covered by it. So just so everybody understands, for instance, a sexual crime. Give me an example of something that's still not covered by this new law.
So sex offender offenses, and in New York there are many. There is the stereotypical image that comes into most of our minds when someone says sex offense, which is a brutal rape, a violation, all the way down to sexual abuse, which could be the case that someone robs someone, a woman, say, and reach into her bra to remove cash and is convicted of a sex offense in addition to robbery. And sexual abuse is a sexual offense.
Right,
so it's a broad category.
Can't be sealed.
That cannot be
sealed. So we have a right to be able to figure that out or to find out about that. And I guess there's a public...
Correct.
All right. Now, give me another example of something else that may not be covered by this, so the viewers understand that...
Violent crime convictions are not covered as well. If you have an A1 felony, which homicide, those types of convictions are not covered. But before we have your audience in the Bronx community listening to this program and automatically removing themselves,
they can't do that.
From you really, if you have ever been arrested, taken to a precinct, questioned by law enforcement, you should really access your criminal history.
Okay.
It's important that anyone who have had justice involvement know the record that the government has on them. Unfortunately, in New York State, you have to pay for your record, but we at the Bronx Defenders assist the community in accessing their criminal histories. I think that's someone's first step. The criteria, as we're speaking about, are not only crime specific, but it's also time specific. So it has to have been 10 years.
Well, that's important. I mean, that's one of the most important parts about the statute is you have to wait 10 years from either being convicted or actually getting out of prison. Am I correct?
Correct.
And that's a long time.
It is.
So what does that mean? During those 10 years, your conviction is still available for employers and a lot of other people to see. I mean, does it defeat the purpose, or is it something that at least helps?
It helps. I think supporters of this legislation may argue and can argue that this legislation is intended for those who have had minimal justice involvement and have moved on with their lives over the past 10 years or more to get an opportunity to seal those convictions. For those of us who stand on the side of expungement being a necessity, that 10-year bar is a pretty high bar for certain people in the Bronx community.
Absolutely. 10 years is best 10 years of your life it could be, and you're having a hard time moving on with your life because you can't get a job because an employer's not giving you one. Speaking of jobs, though, there are certain jobs that you apply for, it won't matter whether it won't be sealed. Am I correct? You want to be a police officer,
correct.
You want to be something else, or what are some other jobs?
That is correct. Let's say a hypothetical client, 19 years old, commits an offense, convicted of a misdemeanor, and 10 years later at 29, 30, decides that they're going to apply for this sealing. They're rewarded with that sealing, and then they're applied to NYPD or to Rikers to work in corrections. This is revealable to those entities. If you are applying for a job in law enforcement or as a peace officer, an employment status that allows you to have a gun and to be licensed to carry a gun.
I think that would make sense. I mean, if you're going to be carrying a gun and you do have a past violent felony, not just a felony or a misdemeanor, we'd want to know it. I know you're on the other side on that maybe, but I think just from the public's perception, I think there are certain jobs we would like to know what kind your criminal history is. Where are we going with this particular law? I mean, is it New York's becoming a much more liberal state? Where do you see this going? Do you think it's going to be reduced down to 5 years? What are your thoughts on that?
Well, my hope is that this will be the first of many looks at our criminal justice system and ways that we punish people well beyond what punishment was rendered in a courtroom. So perpetual punishment is a real thing. If you have been arrested often, but definitely convicted of an offense, I mean, the American Bar Association lists almost 47,000 laws and local ordinances nationwide, which prevents you from ever being civically whole again. And I think my hope is that in New York State, we take a look at that. We allow people who have made poor choices and who have been punished to move on with their lives.
I mean, who hasn't made a poor choice in their
Exactly.
life? And you don't want a choice to follow you and prevent you from being able to rehabilitate yourself. Any final tips to somebody who may be watching tonight and has a conviction that they would like to be sealed at the very least? We can't say expunged, but at least sealed. What would you tell them?
Well, if they're a Bronx resident, they can come to our offices at 360 161st Street. We have a community intake system that they can undergo. If they are not a Bronx resident and they choose to go and navigate this on their own, I would advise that they begin with accessing their criminal histories, their rap sheets. You need to know what's there in order to know and develop a strategy as to what's sealable and what's not sealable.
Wesley, good stuff. And we expect you to come back and give us a little bit of an update, hopefully in the next 6 months to a year, all right?
Yes, thank you.
All right, well, that's all the time we have for tonight. I'd like to thank our guests for joining us, and of course you, the viewers, for watching. If you missed any part of tonight's show, be sure to check it out at www.bronxnet.tv. Also remember, if there is a legal issue or topic you'd like to see on a future edition of Today's Verdict, feel free to contact me at davidlesh@bronxnet.org or tweet us at Today's Verdict, and make sure to hashtag #AskToday'sVerdict. From myself and all of us at Today's Verdict, always remember, know your rights, know your issues, reach a verdict. We'll see you next time.